Hey everyone, my name is Kate Klein. I'm with the Mining and Justice Solidarity Network. I have the pleasure today of being joined by Teresa McClenahan, Carrie Blaze, and Rick Lindgren from the Canadian Environmental Law Association. And together we're going to be talking about Bill 197. Thank you all for joining me.
You're welcome.
Teresa, do you want to start us off by telling us a little bit about CELA?
Sure, thanks, Kate. So CELA is 50 years old this year. We were formed in 1970 by students at the law school at U of T to help clients fight about environmental issues in their communities. And since then, we've played a pivotal role in making sure that the environment is safer and cleaner and healthier for people. For example, we helped pass the Ontario Environmental Bill of Rights and much other important legislation in Ontario. Campaigns we led included removing lead from gasoline, banning asbestos, regulating pesticides. So we represent thousands of clients over the years, representing low-income communities and remote and Indigenous communities to advocate for better environmental protection. And we've been shaping environmental law in Canada ever since, such as the Concerned Walkerton citizens when the drinking water tragedy struck them 20 years ago. We also have worked with First Nations in Northwest Ontario and Southwest Ontario to develop source protection legal toolkits to help protect their drinking water. So just a few examples of the kind of work we do. We work with all kinds of partners, hundreds of colleagues, and we are working, for example, now on ensuring vulnerable communities are protected from climate change in Ontario municipalities. So in the future, we're going to continue doing that kind of work. We especially pay attention to environmental health, clean water, air pollution. And as a legal aid clinic, we work with our sister clinics, other health partners, educators, service providers, academics, to make sure we're collectively protecting all of our population of Ontario, and especially the most vulnerable among us. So we hope you'll want to stay engaged with CELA, pay attention to our work, speak out for the most vulnerable among us, call for strong environmental protection laws, and support our work.
Amazing. Well, I'm so glad that you are all here with us today. So Carrie, Rick, I'm hoping you can help me out here. What is Bill 197 and why do you think it's important to pay attention to from an environmental perspective?
Sure. Thank you, Kate. So let's go back. Where did Bill 197 come from? Why is this in the news? Why are we here talking about it today? So on July 21st, 2020, Ontario passed Bill 197, which was named the COVID-19 Economic Recovery Act. And before the bill passed, there was no public notice or comment opportunities provided on the Environmental Registry, which is required under Ontario's Environmental Bill of Rights. So upon the passing of Bill 197, this prompted Ontario's Auditor General to call out the province, saying they broke the law with the passing of the bill by disregarding the Environmental Bill of Rights. And it also prompted a number of individuals, environmental groups, including CELA, and First Nation communities to launch court actions against Bill 197. So despite Bill 197 being called the COVID-19 Economic Recovery Act, it actually ignores worldwide calls to action for a green and just recovery. And this is totally out of step with public sentiment and renewed calls to action, both for the climate, for biodiversity, and a just recovery.
What is being changed about environmental assessment practices in Ontario through this legislation? And what are some of the potential consequences of these changes?
So previously, the Environmental Assessment Act in Ontario applied to all public sector undertakings. So these are projects that provincial ministries were doing or public bodies, but crucially private sector projects. So factories, mines, residential subdivisions, none of that was subject to the Environmental Assessment Act. Now, this longstanding approach has been altered, but not improved. So now the Environmental Assessment Act will only apply to specific types of public or private projects that are prescribed in a regulation passed by Cabinet. So Cabinet now has the unfettered discretion to pass a new regulation that lists the projects that will or will not get an EA, an environmental assessment. So this means before we've even done the environmental assessment process of what are the economic, environmental, socioeconomic, cultural, and health effects, Cabinet is deciding what projects will or will not undertake an environmental assessment process.
So what concerns you about that?
Well, we have a number of concerns about Bill 197, but in particular, we're concerned about how it changes the application of the Act. For example, as Carrie just indicated, before Bill 197 was passed, the Act automatically applied to undertakings being proposed by the provincial government, municipalities, or other public bodies unless they were exempted. But now under Bill 197, those types of undertakings are not going to be subject to the Act unless they're designated on the regulatory list, which, as Carrie indicated, will be prepared by Cabinet in its discretion. And in our view, this new approach narrows or restricts the application of the Act. And that's simply because anything that's not on the list will not trigger comprehensive environmental assessment requirements. And our concern in that regard is really amplified by the recently released project list that the Ontario government is now seeking public comment on. In our view, the list is incomplete, it's inadequate, and it excludes way too many environmentally significant activities. And so, for example, the list as drafted only includes a few types of electricity projects, a few types of landfill projects or incineration projects, a couple of other project types. But at this point in time, the list does not include mines, quarries, refineries, smelters, sewage treatment plants, and a whole host of other facilities or activities that can and do pose adverse environmental impacts. I would also point out that the current list does not include governmental plans or policies like long-term energy plans that are also very environmentally significant and should be subject to EA requirements. Now, at the present time, Ontario is currently consulting the public on the proposed list. This is a really important opportunity for everybody in this province to express their views on how the Act should be applied. And so we're encouraging everybody to submit comments to the Ontario government before the public comment period ends on November 10th. And if people need more information about the EA changes or the project list itself, I would invite you to take a look at our website, CELA.ca, and there's lots of information about what's going on right now.
So the Canadian Environmental Law Association, alongside a number of other parties, are launching a legal action against this legislation, but the bill has now passed. Is there anything that can be done about this now? What could the average person watching do if they're paying attention and mad and wanting to take action?
Excellent question. So in our litigation, we are asking that the court direct the Government of Ontario to conduct meaningful public consultation on the environmentally significant aspects of Bill 197. But pending that legal action, there's a number of things that can be done right now. So my colleague Rick mentioned the November 10th deadline, and this deadline is the deadline for public comments where you can share your concerns, your values through the environmental registry on the proposed environmental assessment projects list. So this list of projects that would need an EA under the amended law. And when you go to the environmental registry, there's this easy search function. You can pull up this notice and comment on it. And the number, get your pen and paper ready, is 019-2377. And beyond commenting on November 10th, again, this is the first of many regulations and policies and guidelines we're expecting. So making sure the public voice is strong now, ensuring there's pushback now on the concerns within this bill is crucial. So let your MPP know, let the ministers responsible for these changes know, and let the Premier know. And we can change what is currently in the Act because there's a number of provisions that have not yet been proclaimed into force. And so with enough pushback and enough of the public voice saying that we want credible EA, we want projects to undergo comprehensive cumulative effects analysis so we are cognizant of climate and biodiversity and sustainability effects, we can push back so we can change what comes out down the road.
Wonderful. Well, thank you all so much for helping us understand this. I think it's so important that everybody really gets these changes that are being pushed through and also understands what they can do to take action, especially given how quickly it all happened. Much appreciated.
You're welcome.
Great, thank you,
Thank
Kate.
you.